Thank you for joining us today for an update on legislative changes to data practices and the open meeting law during the 2021 regular and special legislative sessions. For those who aren't familiar, the Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. We help the commissioner with issuing advisory opinions, and we also provide legislative assistance and training. This PowerPoint is posted to our website, so if you'd like to go back and take a look, it's on the page where you registered. We also record our webinars, so if you missed part of today's webinar or want to go back and watch it again or find one of our prior series, those are posted on our Data Practices Office YouTube page. And I can actually show you how to find those videos on our website, which is the link on this slide. Okay, so this is the Data Practices Office website, and as you can see on here, you can find guidance about data practices as well as the open meeting law. Also down here on the bottom of our page, right in the footer, you can find the link to the YouTube channel right there. You can also find more information about the YouTube videos if you go to our events page and go to webinars. And this is where we have a lot of the information about the webinars that you can actually find on our website here. So on this page, you can find an audio FAQ. So if you're having difficulty with your audio during the webinar session here, you can just go to the read the audio FAQs right here. Also, we have all of our presentation slides from our past webinars right down here, and you can actually find today's slides under other data practices and open meeting law guidance webinars right here. You can also access our Data Practices Office YouTube channel by going to this link right here. So I'm clicking on that. Okay, on this page, you can actually find all of our videos from our past webinars and their various trainings right on this page. On here, we have videos from the Data Practices Potpourri series, the Law Enforcement Data Webinar series, Government Personnel Data, as well as the Open Meeting Law. And you can find some of our other past webinars down here, including the one we did last week, the After the Chapter 12 Emergency Data Practices and Open Meeting Law Guidance webinar. So I'm going to stop sharing my screen. Okay, if you'd like to download a copy of today's PowerPoint slides, I'm actually going to share those with you right now. Okay, so you should have a screen popped up here, or a box popped up on your screen where you can actually download the slides and save those to your computer. I'll also share the slides near the end of the webinar for anyone who joins later or misses it this time around. A pop-up window should appear and then on your screen, and then you can download it from there. This PowerPoint is also posted on our website where I showed you just a minute ago, so you can get a copy there as well. Okay, for today's agenda, the Minnesota legislature wrapped up its regular legislative session back in May and then continued its work during the special legislative session that started in June and concluded earlier this month. During these sessions, the legislature made several changes to data practices, related statutes, as well as to the open meeting law. So we're going to take time today to highlight some of those changes. We're also going to take the opportunity to remind everyone about the requirement that government entities must update their data access policies by August 1st of each year, and we'll spend a few minutes walking through the areas of our website where you can get some guidance on these types of issues. As a quick note up front, the changes we discussed today are by no means an exhaustive list. Rather, we plan to highlight changes that affect a broad number of government entities. We sent a more comprehensive list of our changes in our recent newsletter, which is now posted on the Data Practices Office website. I've included a link to the newsletter on the final slide of this presentation. Additionally, the legislature often adds data practices requirements in very specific legislation, which our office doesn't always catch. So we've done our very best to highlight all changes in our newsletter, but there may be others that we did not see. So be sure to review any legislative changes applicable to your entity to make sure you're familiar with any new data practices requirements. One other thing to mention here, we won't actually be holding a live Q&A session today about the various legislative changes. Many of these changes are to laws outside of the Data Practices Act, so our office is limited in providing guidance for how to implement many of these new changes. Our goal today is to help make sure you're aware of new data practices requirements. We recommend checking in with your entity's legal counsel to make sure that you're updating any processes or procedures so that you're adhering to the law. Of course, you can always feel free to reach out to our office directly if you do have questions about data practices or the open meeting law. We're always happy to help. So let's start with reviewing some of the changes the legislature made to data practices, including amendments to existing data practices provisions, the creation of some new requirements for government entities, and the reestablishment of a legislative commission. As we're going through these changes, I'll primarily be citing the statutory sections that have been amended or added. If you'd like the specific citations to the session laws that made the changes, I recommend taking a look at the newsletter from earlier this month. I have a link to the page on our website at the very end of these slides, as I mentioned earlier. All right, we're going to start with some changes to data practices requirements for law enforcement and other criminal justice agencies. First, we have Minnesota Statutes Section 626.8457, which was a section added during a special legislative session last year as part of the legislature requiring the Post Board to create a real-time statewide database to evaluate training effectiveness and to identify when a peace officer is in crisis or likely to violate board policies. When the legislation was initially signed into law, local law enforcement agencies were only required to share public data with the Post Board. However, Chapter 11 of the first special session laws amended Section 626.8457 to require chief law enforcement officers to provide the Post Board with any public and private data about officers that the board needs to operate the database. In other words, the language provides authorization and creates obligations for law enforcement agencies to disclose private data as well as public data about officers that the Post Board identifies and says it needs in order to carry out its duties under 626.8457. Let's move on to Section 13.824, which governs law enforcement agencies' use of automated license plate readers, or ALPRs for short. Under 13.824, Subdivision 6, law enforcement agencies must conduct biennial audits of those systems, and the legislature made a minor change to the subdivision to indicate that the report summarizing those results of the biennial audit must be sent to the chairs of the House and Senate committees that have jurisdiction over data practices and public safety issues. This change just clarifies which legislative officials should receive these reports, and you will still need to submit the ALPR reports to all officials listed in Section 13.824, Subdivision 6, which does include the Commissioner of Administration. So if you work for a law enforcement agency that operates ALPRs, make sure your agency is completing these audits and forwarding the reports to the appropriate officials. Similarly, the legislature also updated part of Section 13.825, which is the section governing law enforcement agencies' use of portable recording systems, also known as body cameras. Agencies using body cameras must complete a biennial audit of its systems and data procedures, and the report summarizing those results must now also be sent to the chairs and ranking minority members of the House and Senate committees overseeing data practices and public safety issues. And that's in addition to the governing body with jurisdiction over the agency's budget and the Legislative Commission on Data Practices. Both of these changes went into effect on July 1st. Okay, we're also going to cover a few more law enforcement and criminal justice data provisions before moving on to some other data practices changes. First, the legislature added Section 611A.95, which governs the process for state or local law enforcement agencies when receiving a certification request for U visa eligibility, which is a non-immigrant status for victims and witnesses of specific types of crimes who may be helpful to law enforcement and government officials in investigating or prosecuting that criminal activity. In addition to describing process requirements, Section 611A.95 indicates that the data state and local law enforcement agencies receive and maintain as part of the certification request are classified as private. Furthermore, law enforcement agencies are prohibited from disclosing the immigration status of victims of certain criminal activity, as defined in Section 101A 15U3 of the Immigration and Nationality Act. However, agencies may disclose the victim's immigration status in order to comply with federal law or legal processes, or when they have obtained consent from a victim or the victim's legal representative who has requested certification for U visa eligibility. Next, we're going to focus on Section 634.045, which is a new section governing data related to county attorneys' use of and benefits provided to jailhouse witnesses, meaning a person who, while incarcerated, claims to have obtained information from a criminal defendant or suspect and offers or provides testimony about statements that the defendant or suspect made. Specifically, Section 634.045 requires county attorneys to provide information to the Commissioner of Corrections about the identity of jailhouse witnesses, the substance and use of testimony of that jailhouse witness, as well as the agreement to cooperate and any benefits the prosecutor may have offered to the jailhouse witness. The Commissioner of Corrections is obligated to maintain this data in a statewide database for 20 years from when the information was entered. This data about jailhouse witnesses are classified as confidential, but the Commissioner has authority to share data with county attorneys upon request. Additionally, Section 634.045 includes specific requirements for county attorneys to share information about jailhouse witnesses with the defense in a case, as well as notify victims if certain benefits are offered to a jailhouse witness. Okay, one last change I wanted to mention here that's related to law enforcement. The legislature amended Section 13.41, which governs licensing data held by state licensing agencies, to classify the personal telephone numbers and email addresses of peace officer licensees and applicants for licenses that are maintained by the Post Board as private data. Additionally, the legislature deleted the provision in Section 13.41 that classified data identifying the government entity that employs a licensed peace officer as private, meaning that those data are now presumptively public. In other words, the Post Board cannot disclose personal telephone numbers or email addresses of licensed peace officers or licensed applicants to public data requesters. However, the board can provide data to the public about which government entity employs a licensed peace officer. One note of clarification here. This change was made to Section 13.41, Subdivision 3, which specifically governs data maintained by the Post Board. This change does not apply to any other state licensing boards, which need to follow the requirements of other subdivisions within Section 13.41. Additionally, this change does not impact law enforcement agencies that employ an officer, and an officer's personal telephone number, home address, and any personal email address would likely be classified as private personnel data under Section 13.43 when maintained by local law enforcement agencies. All right, we're going to turn to some other changes the legislature made to state laws affecting data practices. First, the legislature provided the Office of the Legislative Auditor with authority to conduct special reviews to investigate allegations that certain individuals or organizations have not complied with legal requirements governing the use of not public government data. To clarify, OLA can only investigate individuals or organizations that are subject to legislative audit, meaning most state-level entities and some metropolitan agencies. So the data practices folks at these types of entities will want to be aware of this additional level of potential oversight when it comes to data practices, and will want to ensure that they are adhering to all necessary requirements for securing and protecting not public data. Next, the legislature amended language related to who may access vital records, as well as added new language regarding the classification of data in certain applications for such records. To start, the legislature made changes to section 144.225, which governs who may obtain certified birth or death records. The first change is that the legislature removed language that permitted the party responsible for filing the vital record to have access to a certified birth or death record, meaning that the filing party no longer has authorization to obtain a certified copy of these records. The legislature also clarified language so that a certified birth or death record can be issued to an attorney only when the attorney represents the subject of the record or other authorized person. Previously, the language simply stated that a certified birth or death record could be issued to an attorney upon evidence of the attorney's license, and there were no other conditions limiting access by any licensed attorney. So the new language does limit the number of attorneys who can obtain certified birth or death records. Additionally, the legislature created a new section, 144.2255, which governs certified birth records for homeless youth and the application process to obtain these records. This section classifies the signed statement that the subject of the birth record is a homeless youth as private data. Additionally, a statement from a human services agency that verifies the individual is a homeless youth for the purposes of obtaining a birth record is also private data. The next change that we're highlighting is to section 245.4874, which creates requirements for counties to conduct mental health screenings of children in certain situations. The legislature amended language to clarify that the screening results are private data, but counties and tribal nations are permitted to share the results with the commissioner of DHS for the purposes of program evaluation and improvement. Previously, DHS was prohibited from collecting individual screening results. Okay, let's now turn to section 299C.76, which is a new section the legislature created regarding background check requirements, including fingerprint collection, for employees and independent contractors who work for the Department of Revenue, DEED, DHS, MNsure, Minute, and counties in Minnesota, and have or will have access to federal tax information. For data practices purposes, all data that are collected, created, received, maintained, or disseminated by these entities as part of the background check requirements are classified as private data. Additionally, government entities are not permitted to further disseminate the results of these background checks. All right, one additional update that we wanted to discuss from the special session is that the legislature reestablished the Legislative Commission on Data Practices under section 3.8844. This commission is a continuation of the same commission that expired back in 2019, and its duties include reviewing and providing the legislature with research and analysis about emerging data practices, data security, and personal data privacy issues. The body must also review and make recommendations on proposed legislation related to the Data Practices Act, as well as review and propose legislation that impacts personal data privacy rights, data security, and similar issues. The commission will be made up of 4 legislators from the House and 4 legislators from the Senate, and these legislators are appointed by the House Speaker, the House Minority Leader, the Senate Majority Leader, and the Senate Minority Leader. And appointments must be made at the beginning of the regular legislative session in an odd-numbered year. The chair of the commission will also alternate between the House and the Senate every odd-numbered year. Additionally, the commission can elect up to 4 former legislators who have interest in government data practices and personal data privacy to serve as non-voting members of this commission. Finally, the commission must convene its first meeting by August 1st, 2021. So this is definitely a legislative group that folks will want to keep an eye on if you're interested in staying up to date about data practices issues at the legislature and the types of concerns that legislators are attempting to address. Also, government entities should be familiar with this commission because there are obligations to send specific reports to this group of legislators, such as the results of automated license plate readers or portable recording system audits. All right, let's now turn to some of the changes that have been made to the open meeting law. And just as a reminder, we discussed some of these changes during our webinar last week, focusing on open meeting law considerations now that the statewide Chapter 12 emergency has ended. The recording of that webinar is available on our YouTube page, so certainly feel free to go back and review that session for a broader discussion of current open meeting law requirements. So, all the changes to the open meeting law that we're going to discuss were contained in Chapter 14 of the 2021 regular session laws, and many of these changes will go into effect on August 1st, 2021. To start, some of the language related to remote meetings received an overhaul during the regular legislative session. Specifically, the legislature added a new section to the open meeting law for definitions. The legislature also defined the term interactive technology, which means a device, software program, or other application that allows individuals in different physical locations to see and hear one another. Additionally, the legislature amended several sections of the open meeting law to remove the terms other electronic means and interactive television, neither of which had a defined meaning. The legislature replaced those terms with interactive technology. In short, the legislature's changes now provide a clearer definition for what types of applications or software that public bodies may be able to use in order to hold a remote meeting that complies with the open meeting law. The legislature also amended the requirements of Section 13D.01 related to the Journal of Votes. As you may recall, the Deputy Commissioner of Administration opined in Advisory Opinion 21-001 that the plain language of Section 13D.01 indicated that a collection of meeting minutes did not satisfy the requirement that a public body must maintain a separate journal containing a record of its votes. However, the legislature amended this section so that public bodies can now maintain their records of votes in a collection of meeting minutes or as a separate journal. So public bodies can now choose which process works best for them to maintain their record of votes. The legislature also added language to Section 13D.01 to clarify that any minutes that are used as the record of votes must be open to the public during all normal business hours wherever the public body's records are kept. So regardless of how the record of votes are maintained, the record must still be physically available to the public upon request for inspection at the public body's office. All right, let's turn to some changes that the legislature made to the requirements for holding some different types of remote or hybrid meetings under the open meeting law. First, the legislature amended Section 13D.02, which governs other entity meetings by interactive technology, to clarify that this section does not apply to meetings of state agencies, boards, commissions, or departments, or a statewide public pension plan. In other words, Section 13D.02 is reserved solely for use by local public bodies, such as school boards, city councils, county commissions, or other similar bodies. State-level public bodies cannot use 13D.02 to hold a meeting by interactive technology. As just a reminder, state-level bodies still do have the option to meet by telephone or interactive technology, so long as they meet the requirements of 13D.015. Our webinar last week about open meetings and data practices after the statewide Chapter 12 emergency covered the different requirements of remote meetings, and a recording of that webinar is available on YouTube, on our YouTube page if you'd like to go back and review some of those requirements. The next change to 13D.02 was to the requirements related to noticing the locations of members who are attending the meeting by interactive technology. Specifically, the legislature amended language to clarify that a public body does not need to notice the locations of members who are attending via interactive technology due to military service or because they were advised by a healthcare professional against being in a public place for personal or family medical reasons. However, if a local public body member is attending remotely for some other reason that doesn't include military service or based on medical advice, then the location notice requirements will still apply. I also want to note that this particular change went into effect on May 7th, 2021. One additional provision related to Section 13D.02 that local public bodies should be aware of is Section 7 of Chapter 14 of this year's regular session laws. That section indicates that any meetings held after December 31st, 2020, but before July 1st, 2021, satisfied the requirements of 13D.02, even if a qualifying member of the public body participated from a location that was not accessible by the public more than 3 times. In other words, the 3-meeting limit for members participating remotely due to military service or for medical reasons was waived from the beginning of January 2021 to the end of June 2021. This section was effective retroactively for meetings that occurred on or after January 1st, 2021. One final change the legislature made to the open meeting law was in section 13D.021, which governs meetings by interactive technology during a pandemic or Chapter 12 emergency. As we discussed in our webinar last week, some public bodies may still be able to hold remote meetings under the requirements of section 13D.021, even though the statewide Chapter 12 emergency ended on July 1st. So the state legislature added a new subdivision to section 13D.021, which requires public bodies, when holding remote meetings, to provide members of the public, to the extent practical, with the ability to provide public comment from a remote location if the public body's practice was to permit public comments during in-person meetings. In other words, if your public body or entity typically reserves time for public comment during in-person meetings, you are obligated to find practical ways that would allow the public to provide comments during remote meetings held under section 13D.021. This requirement goes into effect on August 1st. All right, I'm going to turn the webinar over to Katie now, who's going to provide some reminders about Data Practices Act requirements regarding the different procedures and policies that are required by law.
All right, thanks, Casey. Let's see here. So, policies and procedures, they need to be updated every year. They need to be updated by August 1st. So our website, we have some sample policies and a guidance worksheet to help you consider different factors as you're updating your policies this year. I'm going to go ahead and I'm going to share my screen and show you where those sample policies and worksheets are on our website and walk through some of the things that you should be considering as you're updating your policies. Okay, so here's our website. When you go to our home page on our website, if you go to our Data Practices tab, Rules and Requirements, and then Policies, that will bring you to our policies page where we have our model access policies, our policy for ensuring access to not public data, and our sample data inventory. So you can see we actually have 2 separate model policies, one for members of the public and one for data subjects. It's important that you review both of these policies and ensure that you have both and that both are up to date. There are separate policies for members of the public and data subjects because the rights of these individuals are and these requesters are different. If you're just starting to develop your policies, or you're not sure where to start when you're updating them, we've developed this worksheet that's here at this link that walks through different decision points and considerations. It's about 8 pages long with information on data practices and a series of questions to ask yourself and your entity or whoever is responsible for data practices at your entity, so your responsible authority, your designees, to determine what information you should be including in your policies. At the end of the worksheet, we have a checklist for you to review and ensure your policies answer each of the items listed. These things include how your policies will be available for distribution, procedures for submitting written requests, whether responses to requests must be in writing, how to verify the identity of a data subject, whether you're going to require the use of your own consent forms or you're going to accept other consent forms, and how to determine if you do accept other consent forms, whether those meet the required standards, and then when will you consider a request abandoned, among many other considerations that you should be thinking about when updating or creating your policies. You'll also note at the next tab, we have the model policy for ensuring the security of not public data. Here we also link to our data inventory page that's on the next tab. You should be looking at these as well, making sure that these are accurate, that you have them, that they don't need to be updated. So if you're going through your policies and you're updating them and you have any questions or you're wondering if we've seen any other entities make similar decisions, you can always reach out to us and we can discuss things like best practices or other considerations with you, and are happy to have those conversations. If you do choose to adopt our model policies, entities that adopt the model policies linked on our policies page must notify the Commissioner of Administration, and they can do so with this notification template that's already on our website. And so you can just fill that out and send that to us if you are adopting our model policies. So I'm going to stop sharing my screen here. And that is what we have for our webinar today. I'm going to open up a survey in the polling panel, so you can provide some feedback on how you thought the webinar went, and this will help us determine if we should do a similar legislative update webinar in the future. So we'd really appreciate that feedback. I'm also going to shortly share the PowerPoint again, so you have that as well. Okay, it looks like the poll is open, and 1 second here while I open the PowerPoint for you to download. Okay, you should be seeing a pop-up on your screen with a copy of today's PowerPoint. You can go ahead and save that to computer if you'd like to download it. Otherwise, it is available on our website, and you can access it there as well. You can see on the screen, we also have a link to our newsletter. The citations for all of the legislative changes that we talked about today, and some other provisions are in that newsletter that's on our website and available for you to go back to and review if you're ever looking for those sites again. All right, well, we're just going to sit here while the polling panel is open and wait for you to download the webinar, but that is all we have for you today, and we are going to wrap up. Again, feel free to reach out to us directly with any questions.